Yeah. Introduction.
Well, good afternoon, everyone. I'm Jomo Thomas, and along with Queen's Counsel Stanley Starkey John, who is not here this afternoon, and Akin John, we represent Mr. Samuel, Leon Bigabig Samuel, in this matter in which he confronts the state of St. Vincent and the Grenadines. And we have had two decisions now by Honorable Justice Esco Henry. One was back, I think, on June 8th. We had a decision where the state made an application to strike out Mr. Bigabig Samuel's claim, and the court ruled that the claim will not be struck out. Essentially, the court said that the state has a case to answer. And that decision came down, and then the state made an application asking leave of court to appeal the decision. And Justice Henry denied leave because she felt the state did not have any reasonable prospect of success. So that decision came down in late December, and we wanted to bring the media up to date to give you an understanding of the state of play as it relates to this very, very important constitutional case having to do with the right to property of one of the citizens of St. Vincent and the Grenadines. So to bring you up to date and to explain in greater detail the decision of Justice Henry and the origins and so on of this case, I now turn you over to Barrister Akin John. And thank you so much for being here. We are delighted that you're all here.
Thank you very much, Mr. Thomas. Let me join first of all in thanking the members of the media who are present here this morning for showing up at such short notice. I know that your time and attention is taken with a number of pressing matters that affect us as a nation at this particular time. Now, as Mr. Thomas alluded to, Bigger Cement and Aggregate Incorporated, of which Mr. Leon Bigabig Samuel is the managing director, instituted legal proceedings against the state in 2019, challenging a survey process and a survey plan that emanated from that process, which was carried out by officers of the state in the Ministry of Transport and Works and via the Chief Surveyor, purporting to conduct a survey of lands, of which almost 9 acres at Rabaca, the state is alleging are Crown lands. Bigger's position was then and before then and remains now that those lands are in fact lands of Bigger's, and that the state's actions were without merit. They were illegal and they were unconstitutional. As Mr. Thomas has also indicated, back in June, we conducted a press briefing to update you on the outcome of a decision made by Justice Henry from an application made by the state to attempt to strike out Bigger's claim. That application was opposed by Bigger, and he was vindicated in that the court dismissed the state's application as being without any merit. In July of last year, the Attorney General's office then filed an application seeking leave or the permission of the court to appeal the decision dismissing the application. again, quite naturally, Biggar, with the aid of his legal team, opposed that application strenuously as being without merit, and on the basis that there was no prospect whatsoever of the state succeeding if the matter were to be heard at appeal. In December, that application was heard, and Justice Henry delivered her oral decision on the 16th of December, which was reduced into writing on the 21st, I believe it is, yes, the 21st of December. And I will read from the decision, the order that the court made for the record. It reads, the order made on the 16th of December 2020 was 1. The Governor General's application for leave to appeal the decision dated June 24, 2020 is dismissed. 2nd, the Governor General's application for a stay of the June 24, 2020 order is dismissed. 3rdly, the Governor General shall pay to Biggar Cement and Aggregate Incorporated costs pursuant to CPR 65.11 to be assessed if not agreed. Biggar Cement and Aggregate Incorporated shall file and serve its application on or before January the 29th, 2021. And what is very critical is that the court expressly stated in its decision that the basis for those orders were that there is no merit to the proposed ground of appeal, and that the Attorney General had no realistic chance of success. Totally and absolutely vindicating the position that Biggar had taken in opposing the application. As it stands now, what does this mean for Biggar Biggs? It means that the substantive claim remains to be heard, and with the assistance of his legal team, Stanley John Queen's Counsel, Counsel Jomo Thomas, and I, we intend to pursue the progress of this matter so that that substantive claim can be heard within the shortest possible period of time. This also begs the question that it is important to note that notwithstanding the state filed an application seeking leave to appeal the decision to dismiss the striking out application, they proceeded to actually file a defense in the matter. What therefore, you may say, is the merit in pursuing an appeal? It, as from Biggar's point of view and from our point of view, it is purely an effort to frustrate Biggar's efforts and deny him of the constitutional rights to the enjoyment of his property, amongst other things. On that specific issue, my colleague, Mr. Thomas, has very wide experience, and I can have him address you a bit more, and after that, no doubt we will field some questions from you if you have any questions for us.
Thank you, Akin. I think that the transition point of Akin is critically important, because the actions of the state as it relates to Biggar's case is reflective of the government's posture on a whole series of other cases that are brought. It happened in the Ottosan case, where they filed to strike out and then they appealed. It happened in the teachers' case. Teachers, that's Johnson, Daniel, and Thomas, where they filed to strike out and then appeal. It happened in the other case with the Public Service Union on the issue of promotions and so on. They filed to strike out and they filed an appeal. So on all of these cases, the government is unrelenting. It is prepared to go forward and essentially waste taxpayers' money. Because at every turn, whether we are talking about the Otasam case, the teachers' case, the Public Service Union case, the other Public Service Union case as it relates to Jamali White, all of them, the government has suffered crushing legal defeat. And at each turn, it continues in the same pattern. What this shows is that this government, once it locks its teeth into an issue or an individual, it is prepared to attempt to economically assassinate that person, to grind them to the ground, to ensure that they are left sometimes penniless. Because as it relates to this case, we know that initially Bega Biggs' property was improperly closed down on environmental grounds. And now the final assault was to try to take away the man's property. And his legal team is here to ensure that that does not happen. And it should not happen because the government's actions do not comport with the law. It is a clear violation of Bigger's right to the enjoyment of his property and to put his property to productive use. Now, another point needs to be said, that at each juncture in these cases, when the government loses, every application it makes and it loses, it has to pay cost. The government has had a stiff-necked, wrong-headed approach to this whole question. It loses and it simply neglects what the court mandates, what the court demands. It simply says, to hell with the court. In fact, one of the government's lawyers in a conversation recently told me, well, the government don't care, and using the expletive. Prime Minister Gonzalez don't care about what the court says. So this is a clear pattern, but some of us have to stand up. I am really proud of Bigger Biggs that he finally decided that, look, I'm going to take this to court, I'm going to push and demand my rights. And on two wrongs so far, this case is far from over, but on two wrongs so far, Bigger has won. And I'm sure he's buoyed, and we are confident that when this matter gets the full light of day, that the court would again deliver a crushing legal defeat to this vindictive, nasty, repulsive attempt to damage Bigger Biggs in his property rights, to crush him for something which he should be allowed to do as any other citizen in this country, to do whatever he wants to do within the bounds of the law. So those are the statements that we have to make. If anyone from the media has a question, we'll be more than willing to answer.
Good afternoon. Kenton Chancellor Harris in the Caribbean Media Corporation. Mr. Thomas, you said that a counsel for the government said that the government does not care. And you speak about the attitude of the government in these kind of civil rights cases. What then is the purpose of pursuing them? Does it really make sense? You put the court against the government, the court issues hands down a ruling, and the government essentially
it makes sense. It makes a lot of sense. Look, democracy dies in the dark. So you have to shine the light, the torchlight, the legal light into dark corners of state action. And every time a case is brought, and every time the government attempts to defend it and fails, its rule of law, due process bona fides are brought into question. And more people, one by one, village by village, across the country, would begin to question whether this government is prepared to respond to the demands of the court and to live according to the Constitution of St. Vincent and the Grenadines. Because we are a country of laws. We are not a country of men. But evidently, the government action so far is indicative of a situation where no matter what the court says, the government refuses to honor those decisions. But chickens would come home to roost.
But you're making these comments on the heels of an election in which the government was returned to office. All these issues were ventilated before, they were in public domain.
Yes.
And the electorate has acted in a particular way. Do you think that this is some sort of commentary on people's view of the government? Is it an endorsement essentially of what the government is doing?
Well, I don't think so. I don't think that that elections are decided in that way. There are a multiplicity of issues in the elections. The government went up, the opposition went up. People chose the government parliamentarians 9-6. But if we look at the popular vote, and if we understand the kind of despicable misuse of state funds in that last election, even with that, it is clear to me, and I'm sure clear to others, that the government won the elections and lost the country.
And in the case of Mr. Samuel, he obviously has the means or the influence to secure counsel, to act gratis or otherwise for him. What about other people who might be in similar situation, who might not have the means or even the fortitude to pursue legal actions against the state?
Well, that's the point I was making earlier about the government's posture, which is intended to crush people into the ground. Because, you have to have a certain economic wherewithal to engage counsel and to engage competent counsel who can seriously and properly challenge these state actions. But people, I think, are wising up, and more increasingly people are going to attorneys, going to barristers and solicitors and airing their grievances, and more these cases are coming to fore. More and more these cases are going to the court. I think that the unions, the St. Vincent Teachers Union and the Public Service Union, have to be credited for bringing a number of these cases. And the court evidently has responded in keeping with the law, and has continuously battered the government's position on these cases. All we have to do is to keep on pushing.
If I may add to Jomo's comments, Kenton, you make a very valid observation, or you pose a very valid question. The state's role and purpose is intended to protect the interests of its citizens. And in the case of the likes of Bigger Bigs and the other individuals and parties to which Jomo has referred, they've failed to do so. And the court's decisions only vindicate and affirm that reality. It may be that in many instances you are correct. Individuals do not have the wherewithal, they do not have a full appreciation, and they don't know where to begin to even seek legal counsel. In fact, the state has, I cannot say, its finite resources are used in this unmeritorious way against its own citizens. But the likes of Bigger Bigs, the likes of the Otto Sams and others standing up, they do have their impact. It has an impact on the wider populace, it has an impact on the wider citizenry who are able in this age of social media, and I give our people credit. We are a people that are now very willing to speak up and to be critical, and that does place a check on the powers that be. That does place a check on the extent that they are willing to go to oppress or to undermine the constitutional rights of citizens, and I think it should be encouraged. Yes, there is far to go, but there is movement in the right direction.
If I may ask one final question. Why is it important for the government to honor the rulings of the court?
Well, it's almost self-evident, it seems to me. If you are a government of laws, and when you are elected, as happened when the new parliament was sworn in, the Prime Minister, the Attorney General, and all other ministers of government, along with opposition parliamentarians, swore to uphold the laws and constitution of St. Vincent and the Grenadines. They swore, in fact, I think in 2016, the oath was changed to say that we are functioning in the best interests of the people of St. Vincent and the Grenadines. So if you make that swearing, and you act contrary to that, it means that you are not doing what you swear to do, that you are contradicting by your very actions what you swore to do. And any government, it seems to me, who cherishes its democratic bona fides would not want to be in stark contradiction with its oath and with its people.
Indeed, you cannot have it both ways. You cannot, on the one hand, make a case that there is a democratic, constitutional, legal basis on which you take or form government and you are able to govern people. But at the same token, those same laws and constitutional rights dictate that you must recognize judgments, decisions of the court made in the interest of your citizens, and say that there is no need for you to recognize them. It is totally duplicitous. It's illegal.
You mentioned earlier the government misuse of state for any aspect. Can you make one example?
Well, I think that the ways in which the government went about its electoral campaign and the ways in which the way in which it dealt with its events, the use of state property to engage in its electoral campaign, it, in my mind, is unprecedented. I never saw anything like that. I never saw it. And I've been watching elections closely since, 1979.
State property like this.
Excuse me?
State property like this.
Yeah, state resources.
And then like the school and the whole election.
Excuse me?
Like the schools are the polling station.
But that's rather tangential question. I don't want to deal with that really. I'm here to deal with bigger issue. So I made a statement. You asked me to verify it, and I pointed to what I thought was misuse.
Does Mr. Samuel want to give a comment on how the case is going so far?
Mr. Samuel?
Let me use this opportunity to say thanks to everyone who has been, in whatever way, supportive of my venture going forward with the issue from a very early stage. But I must say at this time that I'm very comfortable with a magnificent team of lawyers who I refer to now as the manager of this issue. I no longer managing it. It is in the capable hands of a Queen Counsel, a magnificent lawyer in terms of Jomo Thomas, and Akin, who is the son of Queen Counsel John. I could not have asked for a better team of lawyers. To be honest with you, from the time we went into court last year, 2019, no, the year before, 2019 with this matter, and I see the way the case has been handled by the team, it made me a little bit more relaxed, and I am now in a position where I could focus more on how to survive economically in terms of getting things done that I would have liked to get done before. Everybody know that I have now moved from one of St. Vincent's most progressive business person in terms of in the field of construction, and now moving to farming, and we operate a little kitchen. So now I'm more focused now on that because I'm very comfortable the way the case is going and how it has been handled by the managers. And I would not even refer to them anymore as lawyers, I refer to them as manager of the case. I hope I answered the question now.
Also, is the next step going to be?
Well, the court has made an order in relation to the application that was dismissed for an application to assess costs to be filed by the end of this month. So from that aspect of the matter, we are working on that, pursuing that angle. In relation to the substantive matter, we're still in the very early stages because these interlocutory applications intervene. So we haven't even gotten to the stage yet of the court giving directions for the matter to proceed to a trial, filing of witness statements, etc. But we are preparing ourselves diligently in anticipation that very soon there may be a case management hearing and directions given for the matter to be proceeded.
How much do you think this money will come up?
If you can repeat that for me again, please.
The assessment will reach.
It's still very early for us to be able to make a determination on that. That is something we will have to sit down and look at carefully and prepare and present to the other side. So it would be a bit premature for us to do that. What I can say to you is that there are two outstanding cost applications, as Mr. Thomas alluded to. The cost application in relation to this failed application for leave, and the cost application for the initial application by the Attorney General to strike out, which was also dismissed. Those two applications are to be pursued.
And just as a rule of court, where the court makes a decision and make orders, and in this case on their application to strike out an order for cost, and where significantly in their application for leave to appeal, the court dismissed that application, and more importantly, well, equally important, dismiss the application for a stay, it means in law that they have to carry out the order, the initial order, because their application to appeal was dismissed. So the cost which they owed, which became due, is no longer stayed. And if it is no longer stayed, it means that the state is duty bound to pay because it doesn't have an appeal pending. So
Yeah, I think that's what somebody was asking how soon along with looking for the money due.
well, the government has an attitude. The government don't pay over monies. I mean, we have a whole series of files in here where the government still will water some monies on cost, even though that court ruled so long at the time. They only recently started to pay Mr. Daniel and not Mr. Daniel, Mr. Johnson and Mr. Thomas. All right. Thank you all so much for coming. If you don't have any further questions, and we will keep you up to date as the case progresses through the court.